Real estate ownership isn't just about holding a deed. It's about understanding who holds which rights, for how long, and under what conditions. Every home, lease, or land conveyance is governed by a network of interests and estates that shape possession, control, and value. First, interest in real property, the foundation of ownership. An interest is any legal claim, right, or privilege that affects land. It expresses the degree of control a person has, from total ownership to a temporary right of use. Possessory versus non-possessory possessory interests include the right of possession. These are called estates and let someone live on, use, or control property. Non-possessory interests or encumbrances do not include possession. Instead, they restrict, burden, or financially attach to another's property. Examples: a homeowner enjoys all ownership rights, a freehold estate. A tenant has possession only, a leasehold estate. A lender holds a lien, a financial encumbrance securing repayment. A utility company may have an easement granting access to maintain power lines. The city retains public powers such as zoning or eminent domain. Because multiple interests can coexist, understanding how they interact is essential to determining who controls what. Public versus private interests. Public interests, held by governments to serve community welfare, e.g., police power, eminent domain, taxation, and escheat. Example: a county rezones farmland to residential. This limits private use but promotes public planning. Private interests arise between individuals, such as easements, liens, or CC and RS. Example: a homeowners association, HOA, restriction limiting fence height is a private interest that binds owners within the subdivision. 2. Estates in land, possession and duration. An estate includes possession and has a measurable duration. Estates fall into two broad groups. A. Freehold estates, ownership, possession plus ownership for an indefinite or lifetime period. 1. Fee, simple, absolute, highest form of ownership, perpetual and inheritable. Owner holds the entire bundle of rights to occupy, lease, sell, mortgage, or will. Still subject to public and private restrictions, zoning, taxes, easements. Example: owning a home in fee, simple absolute, but still following HOA design guidelines. 2. Fee. Simple defeasible ownership, subject to specific conditions in the deed. If conditions are broken, ownership can revert to the grantor. Present owner keeps title only so long as the condition remains true. Fee. Simple determinable, ends automatically when condition fails, so long as while. Fee, simple condition. Subsequent, grantor must take legal action to re-enter, on condition that, provided that. Example: land deeded to a church, so long as it is used for worship. Converting it to a store would trigger reversion. Third life estate. Lasts for the lifetime of a specific person, the measuring life. The life tenant may use, lease, or mortgage the property, but cannot will it beyond life. When the life tenant dies, the estate either reverts to the grantor or heirs, reversionary interest, or passes to another person, remainder interest. Per autre vie, for another's life, measures duration by a third person's lifetime. Example: Joe grants property to Mary for the life of Bob. When Bob dies, Mary's rights end. Duties of a life tenant: must pay property taxes and maintain improvements, must not commit waste, neglect, or damage reducing value. B. Legal, statutory. Life estates, created automatically by state law to protect families, not by deed. Homestead, shields a primary residence from most unsecured creditors, does not protect against mortgage, tax, or mechanics liens. Example: credit card judgments cannot force the sale of your home up to the protected amount. Dower and courtesy. Historic spousal rights in a deceased spouse's real estate. Both spouses usually had to sign deeds to convey clear title. Elective share allows a surviving spouse to claim a legal share, often 1/3 or 1/2, of the deceased spouse's estate, even if excluded by will. See leasehold estates, possession without ownership, represent the tenant's rights created by a lease, a personal property interest in real estate. Type, description, example. Estate for years. Definite start and end, terminates automatically, 5-year commercial lease ending, December 31st. 2029, periodic tenancy renews, period to period, until notice, month-to-month apartment rental estate at will. No fixed term, ends by consent or death, friend allowed to live rent-free until further notice. Estate at sufferance holdover after expiration without consent. Tenant stays past lease. Landlord can evict or accept rent. Key distinction. Freehold equals ownership and indefinite duration. Leasehold equals possession for a fixed or flexible term only. 3. How these concepts interact in real life. In one property, the owner may hold a fee simple absolute. A bank may record a mortgage lien. The city exercises zoning authority. A utility has an easement for power lines. A tenant leases a portion of the building. Each layer shapes what can be done with the property. A skilled agent must recognize how these layers affect title, value, and marketability. Memory anchors. POET equals 4 government powers: police power, ownership, taxation, eminent domain, escheat. FSD, fee simple determinable, equals so long as, auto-revert. FSC, fee simple condition subsequent, equals condition, court action needed. Life equals limited by life, lease equals limited by time. Comprehensive review. Summary. An interest is any legal right in property. An estate is an interest that includes possession. Freehold estates imply ownership, fee simple or life estate. Leasehold estates imply possession only, tenants' rights under a lease. Fee simple absolute is the most complete ownership, while defeasible forms add conditional restrictions. Life estates terminate upon death of the measuring life and pass by reversion or remainder. Legal life estates like homestead and elective share arise by law to protect families. Leasehold estates, for years, periodic, at will, at sufferance, define how long and under what terms a tenant may lawfully occupy. Recognizing these distinctions enables real estate professionals to explain title conditions, avoid legal conflicts, and protect client interests.